Rise. Here is Fulton County 11 Judicial Circuit Style Session. The Honorable Judge Scott Lester Society.
Thank you all. Please be seated. All right, let's go on the record with 23 SC 188947, State versus Harrison William Prescott Floyd. We're here today on State's motion to revoke bond filed last week. And I also received and reviewed yesterday Mr. Floyd's response. And Ms. Willis on behalf of the state, and who would be arguing on behalf of the defense?
John Morrison, Your Honor.
Morrison, okay. All right, Ms. Willis, your floor is yours.
Good morning, good afternoon, Your Honor. I'm Fani Willis, District Attorney on behalf of the state of Georgia. Just want to put some things on the record before we begin, and then the order in which we plan to proceed. We're obviously here because Harrison Floyd is indicted for 3 counts. One is conspiracy to violate the Georgia RICO statute, which, as you know, carries a penalty of 5 to 20 years. The second count is count 30 of the indictment, conspiracy to commit solicitation of false statements, a sentence that carries 1 to 2.5 years. And then finally, in count 31, influencing witnesses, which carries a sentence of 2 to 10 years. On August the 29th of 2023, a consent bond was entered in this case. And I know that that's part of the court's official record. The state contends that Mr. Floyd, the defendant that is here before the court today, violated 3 of the 7 conditions of that bond. And those are going to be conditions 5, 6, and 7 as outlined there. The state is requesting, so that there's no mistake as to what we're asking, that his bond be revoked and that he be remanded back into custody for violating 3 conditions of the bond. I tell people often I think numerically, and so I often ask that people do that along with me. 3 is going to be a theme here. We believe, Your Honor, as we talk about Ayala and some other case law, that 3 of the factors he is a risk for, and that he violated 3 of the conditions of bond.
This is Popok of Legal AF. We just saw Fani Willis knock a little rust off, crack her knuckles, get back into the courtroom, handle a hearing involving Donald Trump, in this case, a co-defendant of Donald Trump who violated the conditions of his bond, and she was arguing for him to be put back in jail. That is Willie Floyd. But here's the hot take that I'm doing right now. 1, it was interesting to finally see Fani Willis not just make a one-line comment in court, but actually handle an evidentiary hearing in front of that trial judge. And I'm sure I know the reason why she did it. As I practice law and do trial work as well, there are times I want to make an appearance to kind of take the judge for a ride and get comfortable in their courtroom and get him comfortable with my presentation as an advocate. And I'm sure that was the first thing. The second thing is this particular motion that the Fulton County DA made is not just about Harrison Floyd. It's about Donald Trump. This is the first person using social media to bash and try to intimidate witnesses and trial participants and criminal justice participants. But he took it from the playbook of his cult leader, Donald Trump. And so the importance of it's not just about Harrison Floyd, Black Voices for Donald Trump, a guy you never heard of before, and hopefully after he's convicted, you'll never hear of again. This is about Donald Trump. And that's why she wanted to signal, I believe, that the importance of this to the judge, that she, the Fulton County District Attorney, took it so seriously because it'll set the blueprint and the template for the future about how Donald Trump will be handled. She can't fumble the ball now. She has to draw a line in the sand now to establish the proper precedent and to condition the judge to get him ready for when we're talking about Donald Trump and not Harrison Floyd wearing some neon jacket, drinking energy drinks, and reading a book about Marcus Aurelius in court. I'm not making that up. This is about Trump, not about Floyd. So what happened after that presentation went on for several hours? The judge kind of cut Floyd a little bit of a slack, but the judge is obviously also aware of the bigger context and picture here of Trump. And this is how he's going to handle it in the future. He said that it's not technically a violation of the original bond conditions that everybody had not to try to have contact with co-defendants or witnesses. But I'm going to strengthen the conditions of your release. He modified the conditions of the release in order to make sure it doesn't happen again. And the judge also suggested that he will find other opportunities to tighten up these conditions depending upon Mr. Floyd's future or any of the defendant's future conduct. Here's what he did to spell it out with the new order that just came out, and then I'll tie it back to Donald Trump. The judge now the modified bond order for defendant Harrison Floyd, but just read Donald Trump there, will be as follows. The defendant shall have no contact with any co-defendant, witness, or any person specifically named in the indictment in this case. That was originally there. Now he's added the defendant shall perform no act to intimidate any co-defendant in this case. Shall perform no act to intimidate any witness in this case. Shall perform no act to intimidate any person specifically named in the indictment in this case, and shall do no act to obstruct, and this is the broad catch-all, obstruct the administration of justice, right? With those in place, moving forward, and let me just check the rest of the bond order. He goes on in number 10 on page 2. The defendant shall make no public statement of any kind concerning any co-defendant or witness in this case, or concerning any person specifically named in the indictment. This shall include, but not be limited to, statements in books, statements in newspapers, statements in magazines, television, radio, podcasts, YouTube, Rumble, or any other commercial or self-published media. The defendant shall not communicate in any way, directly or indirectly, about the facts of the case with any co-defendant except through counsel. Shall not do that with any witness in the case except through counsel. Shall not directly or indirectly communicate about the facts to any person specifically named in the indictment except through counsel. And now listen to number 14. The defendant shall make no social media post of any kind on any platform, whether public or private, concerning any co-defendant or witness in this case, or concerning any person in the indictment. This shall include, but not be limited to, mentioning, i.e., at somebody's name, referencing, tagging, direct messaging, following or subscribing to or liking posts of another user that would violate this order if posted by the defendant, commenting on or replying to posts of another user that would violate this order if he did it directly, reposting posts of another user that would violate this order if posted by the defendant, and then defines what the social media platforms are, and that he shall abide by this order. And then at the end, he said, and this is a big one, number 16 on page 2 of the order, the defendant within 12 hours of the entry of this order, that means today, that means by tomorrow, doesn't matter that it's Thanksgiving. Actually, it would be by today, has to delete any previously posted social media posts that violate the terms of this modified order. So he doesn't get a pass. He has to go through and scrub his social media on any post starting today. And so that's the new order. What does it mean for Donald Trump? And that's the point of my hot take. It means that Donald Trump can expect to be treated exactly the same way should he violate. And Fani Willis, who just did a test run to see how this judge would handle it, starting with an easy one, Harrison Floyd. The next one is going to be if we start seeing social media posts and comments by Donald Trump bashing Fani Willis, bashing Jenna Ellis, Sidney Powell, Ken Jespero, any of the other people that have pled guilty already in that case, any witnesses in the case, any people mentioned in the indictment, you're going to see there's going to be one warning shot, boom, and then the judge is going to impose this modified order on Donald Trump in a hearing. Or the judge on his own, now having seen and being forced to modify the conditions of release for Harrison Floyd, I don't see any reason why the judge can't now send out modified orders applied to all of the released defendants, including ones named Donald Trump. So one of two things is going to happen. The judge on his own, what we call sua sponte, is going to modify the order for Donald Trump consistent with what he just did because, you know, he said very often, Donald Trump is not above the law. I'm going to treat him like any other criminal defendant. Well, we got a criminal defendant. Or the judge is going to say, well, Harrison Floyd was a special case because the Fulton County DA came in here with evidence and put on a presentation, and I made a decision, and it doesn't yet apply to Donald Trump. But if Donald Trump then continues to abuse and acts out against people that are cooperating with the DA, people like fake electors that are cooperating with the DA, and challenges them. The way he's doing it, the way Trump is doing it in New York and in the District of Columbia, we're going to be right back now, except we got the added benefit for Fani Willis that she's got the wind at her sail because she just conducted a hearing. She took it upon herself, you know. You want to get a job done, do it yourself. I've been there, and got Judge McAfee to issue these bond orders. I know the headline out there is Judge McAfee refuses to revoke the bond and send him back to jail. That's not the headline. The headline is, as a precursor to a future hearing just like this one for Donald Trump, or the judge modifying bond conditions for everybody, including Donald Trump, here are 12 new things that all the defendants have to abide by, including scrubbing their social media for any current violations. That's the headline. And that's what we're doing here on Legal AF at the intersection of law, politics, and justice. I'll follow the developments in Georgia, in the District of Columbia, in Florida, in New York, in Colorado, in Michigan, in Minnesota, and wherever the law takes us at that intersection of law, politics, and justice. I do it one place, exclusively on the MeidasTouch network. Give me a thumbs up if you like this content. It really does help with the ratings and keep this content coming to you, regularly. And then if you like what we're doing here, you like this kind of work on Legal AF, join us on Wednesdays and Saturdays at 8 p.m. Then you can pick up the video whenever you want on the MeidasTouch YouTube channel and on audio podcast platforms, wherever you get it, for that curated podcast. We do 4 or 5 stories like this every week, twice a week, called Legal AF. For those that don't know, the title means exactly what you think. Until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Hey Meidas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.